Georgia Lennon, and I'm continuing with our family law alphabet series. So last week we spoke about the A words, including applications and affidavits. This week we are moving on to B. So to start, the first B word we have today is barrister, and the second B word or concept is best interest of the children. So the first word, barrister, it's a commonly used term that you'll hear a lot in family law matters. Sometimes it's used interchangeably with advocate or counsel. Basically what it means is they're an individual who has trained specifically and studied to become a barrister, which basically means they're the person that represents you in court normally, and they're very skilled advocates. So they're very skilled at oral persuasion and written submissions to the court. So for example, you'd most often use them in a matter, and your lawyer is able to do this for you as well, but they're not as normally skilled in the area. You'd normally use them for serious things in a matter such as an interim hearing or a final hearing. You might also consider using them as well in circumstances where you have really important documents that need drafting, or a second pair of eyes from a specialist in the area. So you'd sometimes use them to proofread and give feedback in relation to affidavits, binding financial agreements and things like that. So that's what a barrister is. There are different levels of barristers. So there's a junior barrister, and they're not really junior like a junior lawyer might be. They're actually quite experienced normally. And then there is also what's called a senior barrister or senior counsel. And obviously the more experienced they are, the more that they charge, kind of same as lawyers. So that's what a barrister is. The second concept or word is best interest of the children. So this is probably one of the most spoken about things in family law matters or parenting matters. It is a concept or collective that comes from the legislation. So the Family Law Act has a section contained within it called Section 60cc. And what that says is that there are a number of factors that the court needs to consider when determining what's in a child's best interest. So when the courts determine a parenting matter, they want to know that the decision that they're making in relation to your parenting arrangements, whether it's about parental responsibility, the time that the children spend with particular parties, they want to know that they're making a decision that is in the best interest of the children. And obviously that sounds very vague, like what does best interest really mean? And everyone has a different idea as to what that might actually consist of. So what the legislation does in Section 60cc, and I encourage you to look it up, it's basically like a bit of a checklist of things to consider, is it provides a list of things that the court must consider, and that if you are a party in a matter, you must address in your evidence. So for example, in your affidavit, you should include evidence that addresses each of these different things and submissions later once you're in court as to why your proposal or the orders that you seek reflects those things. So there are two primary considerations that the court must consider that hold the most weight out of all the best interests of the children principles. So the first of those is the benefit to the child of having a meaningful relationship with both parents. So this means that children should have a relationship with both parents if there's going to be a benefit to them in doing so. Generally speaking, there will always be a benefit to a child of having a relationship. So there's quite a bit of case law that actually says, look, even if the relationship sometimes is a little bit of a negative one, it's still better than no relationship at all, because a relationship with each parent goes towards a child's sense of identity and belonging. And also, as children grow older, they learn to realise perhaps why they haven't had such a strong relationship, and they can come to that of their own terms, as opposed to it being something that's been forced upon them. However, the second consideration, and this one actually trumps everything else to an extent, is that there is a need to protect all children from a risk of harm. So risk of harm can relate to both physical or psychological harm, or a risk that there may be abuse. So for example, if in a matter there has been family violence, there would be a suggestion probably from the other parent that there is a risk that that may continue and impact upon the child in the future. So if you act for a party, or you are a party that has either been the perpetrator of violence or are alleged to have been, you must try and lead evidence that, one, you're not a risk of harm, but secondly, there's things you can do to try and mitigate the risk of harm. So for example, in a lot of matters, a risk of harm might relate not just to violence, but to drug and alcohol usage. You know, you don't have the capacity to care for that child because you're under the influence. And so you might say, well, I agree to undergo random drug testing, and that might be urinalysis, hair follicle, or whatever, to prove my sobriety. Same in relation to alcohol and CDT, carbohydrate deficient testing. So there's lots of different things you can use to try and mitigate the risk in that regard. In relation to violence, sometimes it might be that the parent has to have supervised time, and you might also say, look, I've gone to anger management courses or other courses and things like that to try and learn and appreciate why, you know, I acted in that way and regret doing so, and I'm not going to do that in the future. So that is a really, really serious part of the best interest factors that are always important to consider. And I'll just run through some of the other ones. So some of the additional other considerations are the views expressed by a child. So obviously this varies depending upon their age and maturity level. So something that a 2-year-old says, like, I want to spend time with mummy, perhaps doesn't hold as much weight as someone who's 14 and says, I do not want to ever see my dad again, for instance. That holds a lot more weight than, you know, a 2-year-old's views. However, technically speaking, children can't determine where they live until they're 18, until they're an adult, but the court does certainly give weight to their views, and particularly as they get older, they're less inclined to make orders against what their wishes are. Also important is the nature of the child's relationship with each parent, and also other important individuals. So that would be grandparents and perhaps other people that they might live with, that they may also get orders to spend time with such people. Also relevant is the extent to which each parent has historically taken the opportunity to participate in making major long-term decisions, to spend time with and communicate with the child, and also how they have historically and moving forward attempted to maintain the child. So this is where child support comes in and is quite relevant. So for example, if you're a person that hasn't paid any child support, even though you should have according to, for example, a child support assessment or agreement, that isn't going to look very good, because you can't really say, well, you can, but it doesn't look good. You can't really say, I want to spend time with my child, I love them so much, but I'm not willing to pay for them. That doesn't really support you in that sense. But also relevant is the capacity of each parent to provide for a child, and it's not just capacity, you know, I have a house with bedrooms, it's, you know, can you emotionally cater for this person's needs? Can you intellectually assist them in this way? And that doesn't mean you have to be Einstein, but it just means, you know, you have to be able to assist the children in the things that they need to achieve. A couple of other quick ones before we finish is the likely effect of any changes. So for example, if you have a matter where, let's say, the children have primarily lived with dad for the last 7 years because mum has, for some reason, been away, and for example, mum then comes back and says, I want to spend equal time with the children, a really relevant consideration there is actually, well, what's the effect of that? What is the effect of kind of, I guess, ripping the children away from having spent and having had this life with dad for the last 7 years to then come with mum? So that's really relevant. Another factor is any family violence or orders that are in place that need to be considered, and any other factor that the court considers relevant. So this is really important in that every family is different in some way, every child is different, and every individual. So this kind of catch-all phrase from the legislation allows the court to take into consideration all of those little intricacies, which is really important. So it might be something in relation to your culture that's relevant to just you, or the traditions in your family that again is just relevant to just your family. So that is a really, really great part of the legislation, in that it can be all-encompassing and account for every single family member and child. So they're the two B words, barrister and best interest of the children. Next time we will be talking about words starting with the letter C, including courts and costs and things like that. So stay tuned, and thank you again for listening.